strict liability offence in this sexual arena, where there's huge penalties as well, I'm accepting of it. Threats to kill or cause serious harm. Section 5 of the 1997 Act, you see the progressive moving through the Act here. Section 5 of the 1997 Act provides that a person who, without lawful excuse, makes to another a threat by means of intending the other to believe it and believe that it will be carried out, to kill or cause serious harm to that other or to a third party, to a third person, shall be guilty of an offence. So, a threat to kill or cause serious... Question?
Will we be expected to get that quote perfect?
Oh, absolutely not. I mean, for all the quotes, for all of the sections in the exams, and people have been doing it in some of the homeworks and so forth, it's, you know, when you're doing it in the homeworks, and if you're putting in some kind of quote, of course, it's like writing an essay. If you write an essay, we expect to see the quotes put in. When you're doing it in an exam, what we want is you to remember what section 2, 3, 4 and 5 are. So you'll be saying section 5.1 creates the offence of a threat to kill or cause serious harm. That's what the marks are going for. If you could remember the phrasing verbatim, that's terrific, but it's not, you know, it's not, that is not where they're looking for. They're looking to find out that you've identified section 2 is assault, section 3 is causing harm, section 4 is serious, section 5 is threat. So you'll even, you know, when you're going through this in your mind, you want to be just going, you know, assault, serious, threat of, you're just those words to link it. Also, I might add, as we're at it, when you're answering questions, you absolutely do not have to be looking towards getting what the judges are saying or trying to memorize any of that. What you want to do is memorize that Pert J or Walsh in DPP and Murray. So you'd be saying, so like, Walsh in DPP and Murray felt that the attention had to be turned to whether the person was an on-duty guard. That would be, you know, that's the first class answer. That's somebody who's saying, I remember the case, I remember there was a split in the case, I remember the judge, and I'm telling you roughly what they said. Nobody is looking for a verbatim of that. If you can, as I said, if you can get a few of these things down, fine, but I wouldn't be stressing on it. The more important thing is just to remember what 1, 2, 3, 4, 5 are. Okay? Thank you. Good question. So no, we don't have to be memorizing all that. Section 5. So actus reus. So the actus reus of this, of the threat to kill or cause serious harm. The actus reus of this crime includes the accused conduct. That is to say, the conduct that resulted in making the threat. So that'll be the posting the letters and phone calls and so forth. The circumstances. That is to say, that the threat to kill or cause serious injury to another person was actually occurring. 3, the result, the making of the threat to another person, and that is it's transmitted. Accordingly, if X made a threat to kill or seriously harm Z in a letter, but the letter was intercepted before reaching Z, then X would not be guilty of that offence. He might be guilty of attempting it, but he's not guilty of the assault itself. Or causing a threat or serious harm. I don't know if any of you have seen it, but I saw it's coming out after Christmas. The richest person in the world, the Hearst kidnapping. There's a very big new film about the Hearst kidnapping after Christmas, and in it, I'm spoiling it. I apologise, but in it there's an element where the kidnappers send a letter saying, if you don't answer in 10 days, we'll cut off your man's ear. And it's posted in Italy, and the Italian post is famously bad, but they were on strike as well. So we didn't actually reach where it was going for weeks and weeks and weeks. And the question then arose as to whether, later on, questions will arise in these circumstances, but was always one that was put out for students. Was that operative? Because by the time it arrived, it had already, there was no threat to it because it actually occurred. But so was there a second action and so forth. They'd cut off the ear by the time the letter had written, had actually arrived. So they did operate